Good afternoon, everybody. Today is Friday, November the 15th. My name is Irene Weisman, immigration attorney, and as promised, here we are with news and topics. So today I want to cover something called parole in place. So the reason I want to cover it is because you probably may have heard the Biden parole that was short-lived, but it was issued in June of this year, and it was active and available for people to apply for just literally for about a few days in August of this year, and I know people that were able to get through very fast with that. Basically, what it entailed was if you are married to a U.S. citizen and are present in the country without inspection, meaning you came through the border without a visa, undocumented, there are no other issues in your case, nothing else that makes you inadmissible. The only issue is the fact that you do not have a lawful admission, married to a U.S. citizen, and in the country for 10 years or longer. You would become eligible for this family parole in place, where they would issue that parole that would allow you to basically adjust your status in the United States without having to leave the country. So when USCIS started implementing this in August, a few states filed a lawsuit and there was an injunction. And several days ago, there was a decision by the federal court basically putting an end to this program. What is happening right now, USCIS put out a statement, and if you go to their website, they will provide the information. They will no longer be adjudicating those applications. If you submitted your application for the family parole and did not receive a decision, you will not be receiving a decision on that. If you had an appointment to go do your biometrics, which is fingerprints and pictures, that will not be happening as well. That appointment will be canceled. So there will be no adjudications going forward on the family parole program. It does not impact the military parole in place that we've had for a long time, for many years basically. What that says is if you personally are, or if you are a parent, son or daughter, a spouse of an active military personnel, or in somebody who is in military reserve, and you are in that situation where you do not have a lawful entry and you are an applicant for admission. The only problem is that lawful entry. You can get parole in place. That's still out there. That is still considered on a case-by-case basis. And if you are in that situation, please reach out. We will analyze your particular situation on a obviously case-by-case basis. For the family situation, for the basically that first situation that I described, that is no longer available. If you are in that situation, there are other available methods of legalizing. The stateside waiver, the 601A waiver, is still available, and there is no requirement for you, to be married before a certain time, to be in the country for a certain amount of years. It just will obviously, just like anything else, it's a case-by-case evaluation, but if you are in that position, if your only issue is the fact that you entered without a visa, or for example on a K1 but did not get married to your fiance, or if you entered on a crew member visa, that 601A waiver is an option for you, and we can analyze your case and see if we can help you if you haven't done so yet. So do reach out. Okay, that's what I wanted to discuss today. In the news, the only thing that I saw that is I wanted to mention the validity of medical examinanations for certain Afghan nationals. USCIS has indicated that there will be indefinite validity for those medicals for certain Afghan nationals. So some relief there for certain individuals. Okay, everybody, that would be it for today. Have a great weekend, and we'll talk on Monday.